Right now, somewhere in this country, a woman who already lost her husband is also quietly losing hundreds of dollars a month she's legally entitled to. Not because she did anything wrong, not because she made a bad decision, because no one at the Social Security Administration told her there was a decision to make. That is the problem, and that is what this is about. The SSA's own actuarial data on survivor benefits combined with independent analyses from the Employee Benefit Research Institute, a non-partisan organization that has spent decades studying retirement income security, documents a pattern that I watched repeat itself for 35 years. Surviving spouses disproportionately claim benefits early at reduced rates without ever being presented with an alternative strategy. The EBRI's research into Social Security claiming behavior has put a number to the aggregate consequence, the total sum forfeited nationally through suboptimal filing decisions, in the billions of dollars annually, billions. Individual cases vary, but a widow who files for reduced survivor benefits at age 60 instead of implementing a deliberate sequencing strategy can easily forfeit between $80,000 and $150,000 or more over a 25-year retirement. That is not a rounding error. That is the difference between financial security and financial strain in the last decades of a person's life. There's a rule at the center of this. It's called the deeming rule, and it is the single provision that causes more irreversible damage to surviving spouses' lifetime Social Security income than any other. I'm going to explain exactly what the deeming rule does, how it works procedurally, and how to navigate around it. But first, let me be direct about the scope of what's happening here. The Social Security Administration does not lie to you. The rules are public. They are documented in a system called POAMES, the Program Operations Manual System, which is essentially the SSA's internal rule book, and it is technically accessible to anyone. The problem is not secrecy. The problem is that SSA representatives are trained to process what you ask for. They are not trained to maximize your lifetime income. And in this particular corner of the law, those two things are not the same. What the SSA doesn't volunteer proactively, clearly, in plain language, can cost you a lifetime of income. That gap between what the rules permit and what the SSA explains is exactly what this is about. I'm Frank Mercer. I spent 35 years as a retirement law attorney, and in that practice I handled hundreds of Social Security cases, appeals, benefit recalculations, filing strategy consultations, and a great many difficult conversations with clients who came to me after making filing decisions they couldn't undo. The Social Security claiming decision for surviving spouses was, without question, the issue I saw mishandled more consistently than almost any other in retirement planning, more than pension elections, more than Medicare enrollment timing, more than IRA withdrawal sequencing. Part of that is because the rules governing survivor benefits are genuinely complex, but part of it, a significant part, is that a widow sitting across from an SSA representative at age 61, recently bereaved, financially anxious, does not typically know she's supposed to ask a strategic question. She asks for help filing, the representative helps her file, and the decision that locks in her income for the next 25 years is made in 15 minutes without anyone in that room having discussed strategy. I saw that pattern so many times that I stopped being surprised by it. What I never stopped being troubled by was the permanence of it. Before we go any further, to me what I'm sharing is educational, based on patterns I observed over 35 years of practice and my understanding of SSA rules as they stood through the end of my career. I am not your attorney. Your situation is unique. Social Security rules change, and I am not practicing law. Use what I describe here as a framework and then verify your specific circumstances with a qualified Social Security attorney or financial advisor before you file anything. If you're watching this in the months after losing your husband, still figuring out what you're entitled to, what paperwork needs to happen, who to call. This is exactly the information the SSA should have given you at the window. They didn't. That is not your fault. And it is entirely preventable, which is why I want to walk through it carefully. Now, let me explain what is actually happening here, and I want to start with the numbers because they are the foundation of everything else. The SSA's own data documents that a substantial portion of surviving spouses claim benefits at the wrong time, meaning they leave money on the table permanently. Permanently. That word matters more here than in almost any other financial context I know of. A Social Security filing decision made at 60 or 62 or even 65 can lock in a benefit level that never fully recovers. Social Security is not like a savings account you can recalibrate. Once certain elections are made, they are final. I want to be honest with you. When I first spent serious time studying the SSA's survivor benefit reduction schedule, the chart that shows precisely how much a surviving spouse loses for every month she claims before full retirement age, I was struck by how steep the penalties are and how few people ever see that chart before they call SSA to file. The POMS documents this schedule in detail, and the numbers are concrete. A surviving spouse who claims survivor benefits at age 60 receives 71.5% of the deceased spouse's primary insurance amount. That is the technical term, primary insurance amount, or PIA, which means the benefit the deceased would have received at their own full retirement age. Claim at 61, the reduction is slightly less. At 62, slightly less still. The benefit steps up incrementally for each month of delay. Wait until full retirement age, which is 66 for those born 1945 through 1954, and 67 for those born in 1960 or later, with a sliding scale in between, and you receive 100% of the deceased spouse's primary insurance amount. Now do the math on that difference. Suppose the deceased spouse's primary insurance amount was $2,200 per month. At 60, the surviving spouse receives 71.5% of that, $1,573 per month. At full retirement age, she would receive $2,200. That is a difference of $627 per month. Over 25 years of retirement, a realistic lifespan scenario for a woman who claims at 60 and lives into her mid-80s, the difference, without any inflation adjustments, exceeds $88,000. And that calculation doesn't account for the compounding effect of cost of living adjustments applied to a larger base. The EBRI's work on retirement income adequacy has consistently found that Social Security represents a disproportionately large share of total income for widows in the lower half of the income distribution. For those women, this is not an optimization exercise. It is the margin between adequate retirement income and poverty. We are routinely talking about $50,000, $100,000, more in cases where one spouse had a strong earnings record and the survivor had a modest one. And yet the SSA's own processing system is not designed to surface that calculation for you. The SSA does not send a letter to a widow explaining all of the claiming options available to her. They answer the questions you ask. If you don't know what to ask, and most people don't, the information stays behind the counter. Let me tell you about a woman I'll call Eleanor, 67, retired administrative assistant from Ohio. Husband passed at 71 after 42 years of marriage. Eleanor did what most people do. 3 weeks after the funeral, she went to the SSA office. She filed. She followed the process. She did everything right. The SSA set up her survivor benefits. What nobody mentioned was the switching strategy. What the SSA didn't volunteer, because they're not required to, was the option that would have added over $300 a month to her income for the rest of her life. Eleanor left that office having done everything correctly, and without the information she needed to make the most important financial decision of her widowhood. The system failed Eleanor. Eleanor did not fail herself. And then there's the deeming rule. The mechanism I promised to explain at the outset. I want to explain it the way I would explain it to a client who had just sat down in my office for the first time. Before 2016, the deeming rule, a provision that forces simultaneous filing for certain benefits, applied only to people who claimed Social Security before full retirement age. If you were past full retirement age, the deeming rule didn't apply to you. You could file for one benefit while leaving another untouched. After 2016, Congress changed that. The Bipartisan Budget Act of 2015 expanded the deeming rule to apply at any age. This was a significant change, and it closed a strategy that many financial planners had used for clients approaching retirement. Understanding exactly how the expanded deeming rule works is essential, because the trap it creates is invisible until you've already sprung it. Here is what the deeming rule does in plain terms. If you are a surviving widow or widower, and you have both your own Social Security retirement benefit available to you, based on your own earnings history, and a survivor benefit available to you based on your deceased spouse's record, and you file for either one of those benefits, the SSA will deem you to have filed for both of them simultaneously. You don't get to say, I only want the survivor benefit right now. The moment you file for any benefit under Social Security, the SSA will look at every benefit available to you and pay you the higher of the two, which sounds, on the surface, like a reasonable protection. The problem is that the higher of the two is determined at the moment you file, not at 70, when your own retirement benefit would have reached its maximum value. Wait, I want to be precise here, because the numbers are what make this concrete. Your survivor benefit reaches its maximum, 100% of the deceased spouse's primary insurance amount, at your full retirement age. It does not grow beyond that. If you wait until 68 or 70 to claim survivor benefits, you receive the same amount you would have received at 66 or 67. There is no growth incentive for delaying survivor benefits past full retirement age. Your own retirement benefit, by contrast, operates on a fundamentally different schedule. Your own benefit grows at approximately 8% per year for every year you delay past full retirement age up to age 70. That means if your own benefit at full retirement age is $400 per month, waiting until 70 produces a benefit of approximately $148 per month, a 32% increase. Those are two distinct growth trajectories for two different benefits, and the deeming rule, if triggered at the wrong moment, collapses the strategy that uses those two trajectories to your advantage. Let me show you what the SSA actually processes when you walk in. The representative pulls up your record. They see two benefits, a survivor benefit and your own retirement benefit. The system is designed to pay you the higher of the two at that moment. The form you sign, the SSA 10, the application for widows' insurance benefits, does not include a field where you indicate that you understand the long-term growth differential between survivor benefits and your own delayed retirement benefit. The representative is not required by their processing guidelines to model both claiming scenarios for you. In 35 years of practice, I reviewed intake paperwork from clients who had filed at SSA offices across different states, and the variation in what widows were told before they signed was striking. Some representatives were thoughtful and went beyond what the script required. Many did not. The SSA has a process for notifying widows about all of their benefit options. I spent 35 years waiting to see it work consistently. The system's default is to process what you ask for. It is not designed to stop you from making a decision that costs you $100,000 over your lifetime. There is also a third rule that the overwhelming majority of surviving spouses never hear about. Divorced widows, meaning women or men whose marriage to the deceased ended in divorce, can still claim survivor benefits based on their ex-spouse's record. The eligibility criteria documented in SSA POMS GN 00305.100 are specific. The marriage must have lasted at least 10 years. The claimant must not have remarried before age 60. If you remarried after age 60, that remarriage does not disqualify you. The ex-spouse must be deceased, and the divorced surviving spouse must not currently be entitled to a higher benefit on another record. The 10-year marriage requirement is a hard line. 9 years and 11 months does not qualify. This is not a provision where SSA exercises discretion. I want to be clear about that because I have seen people assume that close enough applies. It does not. If you are not certain your marriage met the 10-year threshold, pull the marriage certificate and calculate the exact duration before you do anything else. The not remarried before 60 provision is one that catches people. Many divorced widows assume that any remarriage disqualifies them. That is not correct. If you remarried at 58, you may be disqualified, though there are additional rules around what happens if that subsequent marriage also ended. But if you remarried at 62 and your ex-husband died at 68, your eligibility for survivor benefits on his record may well be intact. This needs to be verified in your specific case, but the general point stands. Do not assume remarriage eliminates eligibility before you check. Documentation is required. The SSA will want the marriage certificate establishing the start of the marriage, evidence establishing the duration of the marriage, typically the divorce decree, and the ex-spouse's death certificate. If records are difficult to locate, SSA can sometimes assist, but the burden is on the claimant to initiate the process. The SSA does not routinely inform divorced surviving spouses that this benefit exists. In case after case over my career, a divorced woman in her late 60s had been receiving her own small retirement benefit for years, sometimes a decade, with no knowledge that her late ex-husband's significantly larger earnings record made her eligible for a substantially higher survivor benefit. The money was there. The law permitted it, but she had to know to ask. Let me now explain the optimal strategy because this is the part that determines the outcome. The interaction between survivor benefits and your own retirement benefit creates what I call a two-benefit structure. Two separate instruments, each with different rules, different growth trajectories, and different optimal claiming ages. When managed deliberately, that structure can maximize your lifetime Social Security income by a meaningful amount. When ignored or collapsed prematurely by a deeming rule trigger, it produces an outcome that no one can fully reverse. The core insight is this: you have two separate clocks running from the moment you become eligible for survivor benefits. One is the survivor benefit clock. It starts ticking at age 60, that is the earliest you can claim, and reaches its peak at full retirement age. Past FRA, the clock stops growing. The other clock is your own retirement benefit clock. It starts at 62, reaches FRA value at full retirement age, and continues accumulating delayed retirement credits at approximately 8% per year until age 70. After 70, there is no further growth. Two different clocks, two different peaks. One strategy question: which benefit do you want to maximize and which do you use as bridge income while the other grows? If your own retirement benefit at 70 will be larger than the survivor benefit you're entitled to at full retirement age, here is the structure that most commonly makes sense. Claim the survivor benefit as early as age 60. Accept the 71.5% reduction. Let your own retirement benefit remain completely untouched and continue accumulating delayed retirement credits. At age 70, switch from the survivor benefit to your own retirement benefit at its maximum. You will have collected survivor income for up to a decade, while your own retirement benefit compounded at 8% per year. At 70, you switch to the maximized own benefit and receive that higher amount for the remainder of your life. The genuine uncertainty here, and I want to name it directly, is that the interaction between the deeming rule and survivor benefits in certain edge cases, particularly divorced widows with gaps in coverage or complex earnings histories, has produced inconsistent SSA guidance over the years. The dominant interpretation I've described is the one reflected in SSA POMs and most professional guidance. but verify this specific scenario in your specific case with SSA directly before you file anything. Get the verification in writing. If the survivor benefit is larger than your own retirement benefit will ever be, because your own earnings history is modest, perhaps due to years out of the workforce, the structure flips. Claim your own small retirement benefit as early as makes sense, allowing it to provide bridge income, while letting the survivor benefit continue toward its maximum at full retirement age. At full retirement age, switch to the survivor benefit and collect that higher amount for the rest of your life. The SSA will process this switch if you request it explicitly. They will not do it automatically. What they don't tell you, and this is the part that most directly explains why the problem exists at the scale it does, is that the SSA operates on a service model, not an optimization model. The SSA will give you what you ask for. They will process your application accurately. They will calculate your benefit correctly based on the filing you make. What they will not do as a systematic practice is sit across from you and say, before you file, let me walk you through 2 different scenarios and show you the 25-year lifetime income projection for each. That service does not exist at SSA offices. It is not in their mandate, it is not in their training, it is not in their performance metrics. The SSA's default processing behavior is to resolve your immediate request. If you call and say, I want to start my Social Security, the representative will ask, which benefits, survivor or retirement? And when you say you're not sure, they will most commonly guide you toward the benefit that processes cleanly in that moment. In 35 years of practice, I've seen this cost people everything. Specifically, the inability to undo a filing decision that locked in a lower lifetime income because the SSA representative didn't ask the right question, and the widow didn't know the right question existed. There is also a provision called the Government Pension Offset Rule, GPO, that I need to flag here, and I'll return to it in a moment, in the context of the protocol steps. The GPO can reduce or eliminate survivor benefits for people who receive a pension from a government employer, state, local, or federal, where that employment was not covered by Social Security. This is a separate calculation and it catches people by surprise at the worst possible moment. If you have any government pension in your history, the GPO is not optional information, it is essential. Here is the practical 4-step framework for how to approach this. Step 1. Pull your own Social Security statement. Go to your online Social Security account. Create an account if you haven't already. You will need identity verification, so have your Social Security number and some identifying documents ready. Once you're logged in, download your Social Security statement. Find the section that shows your estimated benefit at 3 ages, 62, full retirement age, and 70. Write down all 3 numbers. These represent the full range of your own retirement benefit, depending on when you claim. Also review your earnings history on that statement and flag any years that look incorrect. Your benefit calculation is only as accurate as the earnings record underlying it. Now you have a baseline for one side of the equation. Step 2. Contact the SSA, ideally in a way that creates a record, and request a written estimate of the survivor benefit you are entitled to based on your deceased spouse's earnings record. You can start the process by calling 1-800-772-1213, but I strongly recommend following up any phone conversation with a written request so you have documentation. When you speak to the SSA, use specific language. I would like a written estimate of the survivor benefit I am eligible for based on my late spouse's record, at my full retirement age, and also at age 60. Get both numbers in writing. Now you have both sides of the equation, your own benefit at 70 versus the survivor benefit at FRA. Whichever is larger is your primary benefit, the one you want to grow to and keep for the rest of your life. The other is your bridge. Step 3. When you are ready to file, be surgically explicit in the language you use with the SSA representative. Do not say, "I want to apply for benefits." Do not say, "I want to start my Social Security." Say specifically, "I want to file for survivor benefits only at this time," or "I want to file for my own retirement benefit only at this time." Use those words. Use the word "only." The deeming rule does not require the SSA representative to ask you whether you want to preserve the other benefit for later. The representative processes what you ask for. The word "only" signals a deliberate, informed election. Write down the name of the representative you spoke with and the date. If the filing does not proceed as you intended, you have a record. Step 4. If you are a divorced surviving spouse, do not wait for SSA to identify your eligibility. The system will not surface it for you unprompted. Gather your marriage certificate, your divorce decree, and your ex-spouse's death certificate. Call SSA and affirmatively state, "I am a divorced surviving spouse and I believe I may be eligible for survivor benefits based on my ex-husband's record. The marriage lasted more than 10 years. I did not remarry before age 60 and my ex-husband is deceased. I would like to explore this eligibility." Use that language. Put SSA on notice that you know this provision exists. And then before you file anything, if you ever received a pension from a government employer, a school system, a state agency, a municipal government, a federal job not covered by Social Security, you must ask the SSA representative to apply the government pension offset calculation to your projected survivor benefit before you make any filing decision. The GPO can reduce your survivor benefit by 2/3 of your government pension amount. For some people, that reduction is manageable. For others, it eliminates the survivor benefit entirely. You need that number before you file, not after. The core of what I've described is this: survivor benefits and your own retirement benefit are two separate instruments operating on two separate growth schedules. The survivor benefit peaks at full retirement age and stays there. Your own retirement benefit continues growing at 8% per year until 70. Those two facts in combination create a sequencing strategy that can be worth tens of thousands of dollars, sometimes significantly more, depending on the size of the benefits and how long you live. The SSA's processing system is not designed to protect you from making the wrong choice. The deeming rule is the trap that makes the wrong choice permanent. Once you trigger simultaneous filing, the sequencing strategy is gone. There is no reset. There is no appeal that reverses a voluntary filing decision simply because the widow didn't understand the long-term implications. I know this because I handled those cases. I sat with those clients. The regret is real. Years of permanently reduced income that she can never recover, money permanently gone because no one in that SSA office was required to explain the alternative. That regret is entirely preventable. Understanding that the trap exists, understanding exactly how the deeming rule triggers it, and knowing the specific language that navigates around it, that knowledge is worth real money. The rules are public. The strategy is legal. The only thing standing between most surviving spouses and this information has always been the gap between what SSA processes and what SSA explains. I'm Frank Mercer. Keep asking the right questions. If you found this useful, subscribing takes 1 second, and it means the next time a rule like this changes, you'll hear about it first.